The Supreme Court this evening dimmed the lights on an application by Kurayangu Sautiyangu and Uhuru to present to the court a report of an audit of all Forms 34A, B and C and a certified copy of the voters' register. Justice David Maraga clarified that the second petitioner was only going to be allowed to give his comments on what they saw at the audit.
It is a basic rule that in scrutiny, you wish to have scrutiny on anything, you must lay a basis in your petition.
In their submission after an audit, the petitioner found that the petitioners had downloaded material that the IEBC had availed at their website. The IEBC had also availed a hard drive. When they looked at both documents, it was evident that there were inconsistencies in the documents.
The returning officer, the constituency returning officer, should feel the handover as he's handing over, and the national returning officer should feel the takeover as they're taking over, and on that basis, they verify, and then that is the Form 34B.
We gave those documents knowing that some of these allegations might come up, but to help the court make a just and fair determination that if there is any human intervention that might arise, do you have a control mechanism?
President Uhuru Kenyatta, in his submissions earlier in the day, asked the court to uphold his victory by stating that the IEBC tried its best to work within the law, yet there were certain quarters that caused violent insurgencies to deny some Kenyans their right to vote.
Request being the incentive to do wrong. An incentive to do wrong would be that a person who now wants to enjoy or benefit from his wrongdoing.
If you elect not to exercise your right and you have slept on it, the consequential factors that are triggered by that, or the consequential factors that are triggered by those who elected to vote, you should sit out in that process. You can't say that I will not participate in this election and then say that this election is wrong because of A, B, C, and D.
The issue of violence being used in the case to urge the court to agree that some quarters of the political class used violence to block some parts of the country not to participate in the vote was heavily discussed, with the respondents, including the Attorney General, insisting that this was against the rule of law.
You will still have to go back to what is the standard, what is the proof, what you need. It must be systematic, it must be widespread, it must be intended, and that the existence of those facts must be proved beyond reasonable doubt. Not by my friend Mr. Dombi. It's not for Mr. Dombi to speak from the bar. It is for witnesses who claim to have been so affected to do so.
The issue of the withdrawal of Raila Odinga from the October 26th poll was also highlighted. President Uhuru Kenyatta saying his opponent willingly abandoned the race instead of legally withdrawing according to the law. But with the Justice Mativo ruling to allow Ekuru Aukot to run in the race, Uhuru Kenyatta, through his lawyer, could not explain himself on the legal process that would follow if only two candidates were in the race and one pulls out.
The Mativo judgment was on the 11th of October.
Yes.
But 5 days earlier, IEBC has said only 2 people are participating.
Theoretical, oblivious of the period of 60 days that the authority would then have called for nominations. But from a practical angle, it would have been difficult for nominations to take place because of the 60-day period.
The president's lawyers argue that the merits of the fresh petition should be dissected based on the contested Electoral Amendment Act that came into law even after President Uhuru Kenyatta said that his conscience could not allow him to sign a bill that would give him an upper hand among his competitors.
First, we start with the presumption that a statute is constitutional unless a contrary position is demonstrated. In my submission, no contrary position is demonstrated.
In his submission, lawyer Ahmed Nasir Abdullahi urged the court to throw out the case as it is a means by civil society to seek international donor funding through the litigation process.
Yes, we will deliver judgment on the 20th.
With the main bulk of the presidential petition submissions finally over, Kenyans are now looking forward to the next few days when the Supreme Court judges will be expected to deliver their judgment on the second time for this presidential petition. Leila Mohammed, NTV, Nairobi.